come to order. Clerk, if you'll call the roll, please.
You have a quorum, Mr. Chair.
Thank you, Madam Clerk. Okay, we're going to do a little bit of housekeeping real quick with the committee because we're going to hear some bills that are going to be exactly the same, some that are a little bit different, and then some that are unique that came out of the House that we didn't have co-patrons on or a similar bill on the Senate side. So the first thing I'd like to do is go ahead and take House Bill 136, 867, and 1005 and block those, and we're going to move those out of here because they reported out of rehab exactly the same with identical bills. So, all right, we have a motion to report. It's been seconded that 136, 867, and 1005 be reported. Members will vote.
Yeas 9, nays 0.
Yeas 9, nays 0. The next order of business is to take House Bill 820 by for the week. Without any objection, I'm going to do that. Okay, now we're going to take up some of the bills that are very similar. So to the House members, I apologize, but I want to try to get some of these that we can conform out of here as quicker so you guys can get out of here. So with that, we're going to take up House Bill 196, Delegate Bolivar, if you're here. If you want to take up 196 real quick. Folks, this is the similar bill to 182, Senator Favola's bill that was PBI'd out of here. So we've heard this bill before, and Delegate Bolivar, if you want to just give us a quick rundown on why we should reconsider it.
Well, thank you very much, Mr. Chairman. I don't know if you need me to go back through any of the history of it. I know that when you all heard it early into the session, there were some specific concerns because it deals with the appeals process for somebody who is accused of found a case of sexual abuse at the state level. And the issue is that you had the appellant who could go ahead and stretch on that appeals process through unlimited numbers of extensions. And so the original bill that came over, or that came to you before, basically said that you could only have an extension for good cause and only up to 90 days. And so I think that gave everybody here a little bit of pause because that didn't consider mitigating factors that might occur. And so that was a very useful conversation. And so we went back in, met with the Commission on Youth, multiple other people, and said, hey, you know what a better idea is to go back and say, hey, the appellant can have up to 90 days, doesn't matter why, but after 90 days, the public or the hearing officer, you have to demonstrate good cause for that. And so, again, it just makes sure that you can't abuse the system, but it also makes sure that the appeals officer can say, hey, after 90 days, you got to show that at least some kind of good cause is shown in order to get that extension.
Thank you. Senator Serville or Senator McDougal, this was your main concern on that process, and I don't know where you are with regard to Delegate Bolivar's bill now, if that suffices for your hesitation the first time.
Mr. Chairman.
Yep.
Speaking of the bill, so I think my concern, I think Senator McDougal shared it, was that sometimes cases have to be continued, and sometimes witnesses aren't ready. Sometimes people don't appear. Sometimes people don't appear for hearing dates. Stuff happens in court, and tying the hands of a hearing officer in terms of continuances we thought was sort of unduly restrictive. I mean, cases are continued all the time, and you know, that we thought that it sounded to us like in this situation you had a hearing officer that kept granting continuances. Maybe the problem was the hearing officer and not the law. And so that's, I think, where we kind of came out. Right?
Okay. All right. Well, we've heard this bill once before, so the committee operates on motions.
I
Okay,
have
it's been moved to
substitute
PBI.
motion. Mr. Chairman, I have a substitute motion.
Okay, Senator Pavola.
I move to report the bill. Again, there's not a box around a hard and fast time limit here. The committee worked, the commission and others worked very hard to address the concerns of this committee. It was voted out of the House 99-0. And this is an administrative appeals process. It does not affect any judicial process that the appellant may want to pursue after this. So I would ask that the bill pass.
I second.
Okay, it's been moved and seconded that the bill pass. Clerk will call the roll.
This is the bill passing.
Correct.
Yeas 5, nays 9.
Thank you, Delegate.
Okay, thank you.
Appreciate it. Delegate Bulova, if you want to take
Mr.
up,
Chairman,
Senator McDougal.
I think we have to go back to the original motion since that's a substitute.
We-
Underlying motion.
Yeah, we do, I'm sorry. Running slow this morning, thank you, Senator. Clerk, do you want to call the roll for the original motion? Which was to PBI. Delegate Bulova, you got 422 as well, right?
Yes, sir.
Okay. All right. Let's take that up.
All right, so 422 is a bill that is almost identical to Senator McDougal's House Bill 306.
Yours just has a third enactment, is that correct?
Mine has an enactment clause that I believe that Senator McDougal is agreeing with, and it really just deals with a unique situation in the city of Roanoke.
All right, Senator McDougal, are you good with that?
Mr. Chairman, yes, we looked at this, and I think that the issue came up after the bill had already passed the Senate and was in the House. We put the same language that Delegate Bulova has currently on his bill, on my bill in the House, and I'm going to ask that we accept it, and I move that we report his bill as it stands.
Okay. It's been moved and seconded to report 422, which is the same as Senator McDougal's 306. Anybody have anything to say? If not, clerk will call the roll.
Yeas
All right.
15, nays 0.
Thank
You're out
you.
of here. You're
Appreciate
done.
it.
Yep. Delegate Peace, are you here? She's not here. All right, Delegate Orrock, is he here? Bob, come on up. Delegate Orrock, we're going to take up 873.
Oh, I'm sorry. I heard
Orrock. Orrock. Did I not say that? Need a starter gun in here.
Teamwork, yeah.
Delegate Orrock, we're going to take up 873 first. That's,
Yes, sir, Mr. Chairman. Y'all had a similar version to this from Senator Wexton. It was an outright repeal of the sunset provision. The House position has been rather not to repeal it, but extend the sunset for 2 additional years. The fundamental premise behind that is the language that also exists with that, in that if the federal regulations change and no longer require the background checks, we would drop to the federal standard. And that's the bill as it stands.
So this
before
is
you.
the same bill that Senator Wexton and Senator Hanger had.
Senator
where-
Wexton's was an outright repeal of the sunset, so that if the federal no longer required the fingerprint background check of our religious institutions, we would still require it. My bill, however, puts us in a posture where within the next 2 years, if the feds change their regs, then we would drop to that lower standard. Senator Wexton's bill has been amended to conform to this version now. I leave it to the committee as to what your pleasure would be.
Well, if we've conformed yours, Senator Wexton, you have a comment?
Mr. Chairman, the delegate is correct, and if they don't change those federal regulations, we'll be back in 2 years doing it again, having this bill pass again. But it's fine in the interest of seeing.
All right. So there's white smoke. Okay, got it.
Mr. Chairman?
Yeah, Senator
Just
McDougal.
to prevent us from having to be somewhere else down the road, Senator Wexton, are you going to agree to the 2-year? Okay.
Okay.
Thanks, sir.
All right. Anybody have anything else they want to ask about it? All right. The motion is to report. It's been seconded by Senator Sproul to vote this bill out, House Bill 873. Clerk, call the roll.
Yeas 15, nays 0.
Okay.
All right. You see my vote, don't you? Remember that.
Delegate Orr, do you have another one in here?
Yes, sir. I think it's in the block, so I presume you'll just take it up
No,
at that
we
juncture.
took it up in the block, so you're
Okay,
good.
so
You're
thank
outta
you,
here.
Mr. Chairman,
Thank
members of the
you. Yeah, you
committee.
bet. I'm going to work back to 820. The reason we were taking it by for the day on the first page is there was possibly going to be an amendment, and the patron was not here, and I wasn't going to try to put an amendment on the patron's bill if he wasn't here to speak to it. That amendment is being withdrawn. It's identical to Senate Bill 382, which reported out of here 15-0. And I
Move to report, Mr.
got
Chairman.
a motion to report. It's been properly seconded to pass House Bill 820. Delegate Knight. Clerk, call the roll.
Fifteen, nays 0.
15-0. That bill's out of here. All right. Delegate Watts, you're up now. Committee will bring their attention to House Bill 301.
Thank you very much. 301 deals with the HIPAA and the release of records to Department of Corrections as well as local and regional jails. I would bring to your attention that 301, it turns out to be a pretty fat bill because the first 9 pages are all one code section that deal with whether or not you can or cannot release records under what conditions. And in 2003, if you turn to line 88 and 89 through 92, you will see that in 2003, specifically, it said that the records could be released to Department of Juvenile Justice facilities. And because there wasn't anything in there about prisons and jails, while you could look elsewhere and kind of find it, and sometimes it's released and sometimes it isn't released. So what 301 does is put everything on the same posture so that it's clear exactly that all 3 types of institutions would be treated the same as far as release of records for the people who are institutionalized.
Any members of the committee have a question for Delegate Watts about what this does? It's a whole lot of pages for 3 lines.
Yes, right, exactly.
Chairman,
Senator McDougal?
That's, maybe staff, do we call them local correctional facilities? I mean, I think, as opposed to local jails?
I thought we call them jails. David, we do call them jails? Do we need to do? Oh, it is, okay. All right. Anybody in the audience wish to speak to the bill? All right, we have a motion to report. It's been seconded to report the bill. Committee will vote. Thank you, Delegate Watts. You're out
Thank
of
you.
here. Delegate Habib. You have 571?
Yes, sir, Mr. Chairman, members of the committee. If you do any criminal defense work, you may be familiar with the statute. This is the underage possession statute. There are 10 exemptions in a referred to statute. One of them is referred to as an affirmative defense. My predecessor carried the bill to create that and accidentally limited only one of them to being an affirmative defense. What that means is the defendant has the burden on that one affirmative defense, but on the other 9 exemptions, the prosecution has to disprove them. What we're seeing in our jurisdiction is a very wily former member of the General Assembly is coming into court and saying that because the prosecution can't disprove that the child was a home brewer, that the prosecution therefore can't convict of underage possession. So this is just attempting to clarify what everybody already thought was the law. The criminal court subcommittee put that this is restating existing law, second enactment clause on there because they don't want to announce to the world that this is a get out of jail free defense between now and July 1st.
Mr. Chairman,
Senator Sproul.
you said those of us who do defense work, my degree comes from law and order. How should I vote for this bill?
You should vote for my bills, man.
Thank
You know
you,
how-
sir.
You know how it is.
Move approval. Move approval.
Mr. Chairman,
Senator Cosgrove.
Mr. Chairman,
Okay. Just a question for Delegate Habib. You said that your predecessor made this glaring omission. Is that correct?
I did, yes, sir.
What is that person doing now?
He is fixing all the problems in Washington.
That's what I thought. Okay, thank you.
This is my predecessor's bill. A former predecessor from the Roanoke Valley is the one who's identified the problem, who's appearing before a judge who may be married to one of these people and using this defense. So,
Mr. Chairman,
I'll get right to you, Senator McDougal. Senator Serval.
question for the patron. Is the patron aware that there's another member of this body who uses similar defenses regularly in Fairfax County Circuit Court who thinks this is the correct interpretation of the law and is what it was intended?
yeah, I mean, look, I got no problem if somebody says they want to keep these as good defenses in those cases. And notwithstanding the amendment that the criminal court subcommittee put on there, if you're doing this work between now and July 1st, you ought to be using this defense in every case. And if criminal justice issues are binary for you, a vote for my bill is the quote-unquote tough on crime position. A vote against my bill is the quote-unquote not tough on crime position.
Senator McDougal.
Mr. Chairman, I'd be interested to see how Delegate Habib is going to vote on our expungement of these convictions before maybe we take action on this.
I'd happily vote for expungement.
Okay. Do you think you'll have 10 of your colleagues with you?
There's one of them right there who I know is going to vote against it.
Mr.
but-
Chairman,
Senator McDougal.
Mr. Chairman, maybe we ought to send this to courts.
I'm
pending
thinking
how
this is a
that's-
lawyer's
how
bill
that
at this
goes.
point.
So I'd move
Look,
this be
man,
re-referred to committee on
I'm
courts.
thrilled to have got my first experience in rehab, but I was surprised it came over here.
I'm surprised to hear it too. So I have a motion to send it to courts, and I'm not adverse to sending it there. So is there a second to send it? All right, it's been moved and seconded to send this thing to courts of justice where I get to hear it all over again. So,
Mr. Chairman.
Senator Hanger, with your input, that bill's out of here. You're going to
Thank
courts.
you. I just had an irrelevant question. You referred to a wily former legislator. Would that be the gentleman from Benton?
It would be, yes, sir.
Okay, thank you.
Wiley's the nicest description I could come up with.
All right, we'll see you again in courts. Thank you,
Thank
Delegate
y'all.
Habib. Delegate Bell, Dickey, one each. Yeah.
Morning, Mr. Chairman, members of
Morning.
the committee. This is House Bill 1366. Currently, a licensed home care organization cannot.
Dickey, let me
establish-
hold you one second.
Yes, sir.
That got re-referred to courts 15-0. Go ahead, sir.
Okay. House Bill 1366. Currently, a licensed home care organization cannot establish branch offices unless the Commissioner of Health issues a license authorizing the licensee to provide services at one or more branch offices, and the address of each branch office is listed on such license. This bill simply says that the branch offices shall be operated under the initial license issued to the home care organization and shall not be required to obtain an additional license as they are now.
Okay. Do any members have a question for Delegate Bell on what he's trying to solve here? Okay. Anybody in the audience wish to speak to the bill? Nobody for or against. Okay. The motion is to report the bill. Is there a second? Been moved and seconded to pass House Bill 1366. Clerk, call the roll.
Yeas 15, nays 0.
15-0. You're out of here, Delegate.
Thank you,
Bell.
Mr. Chairman.
Delegate Peace here. He's going down the queue. Delegate Hope. Delegate Sullivan. Come on up, sir.
Good morning, Mr. Chairman, members of the committee. This is HB 1520, affectionately known as the BYOB bill. Deals with a very important problem in Virginia. There is a time-honored tradition during the summer of heading down to your local community pool on a Friday or Saturday night, maybe with a picnic and a cooler with a couple of beers or a bottle of wine in it. An enterprising lawyer in Northern Virginia discovered, who's a member of a board of a swim club, that that's actually contrary to ABC law unless the swim club has a banquet license. What 1520 does is simply, I think, keep the status quo, or what everyone thought was the status quo, which is that a member of a swim club bringing his or her own alcohol onto the premises for their personal consumption is allowed to do so, and that a swim club does not need a banquet license to allow that to happen. You might ask, what's the big deal? These are swim clubs run, of course, by volunteer boards of directors with fiduciary duties. When it was discovered that this issue was out there, people started fretting, of course, about insurance policies and being in compliance with the law and having to tell people they could no longer do this. So it simply fixes what really shouldn't be a problem, and I would hope you would agree with me on that.
Delegate Sullivan, do these swim clubs have enough liability insurance so if we start having these things happen at pools, they're going to be covered for?
Well, the answer is I would expect so, Mr. Chairman. This, as I said, this is something that happens regularly. Frankly, no one thought it was a problem, and no one's particularly worried about ABC coming and busting these places. It's really a compliance with the law issue and just making sure that an insurance company, for instance, doesn't say, well, wait a minute, you weren't in compliance with the law, so we're not going to cover a particular incident.
So is ABC here, is Travis here, or you guys have heartburn with it, Travis? No? No position either way, as usual?
Mr.
Okay, got
Chairman,
it.
down here, maybe if
Senator
Travis
Dougal.
could come on up.
Sure.
Come on down.
I think he needs to be sitting in the front row.
Yeah,
not in the
he's
back
trying to
row.
hide in the back. I've noticed that.
Mr. Chairman.
Good to see you this
Chairman
morning.
Dougal.
Travis, if
Yes,
we
sir.
do this, do we need to do it for private golf clubs, private hunt clubs, any private organization? I mean, this seems to be a very large set of Christmas trees, maybe a whole Christmas tree yard.
Mr. Chairman, I would say extending this exception to others would certainly be a policy decision of this body. I would think that it would be attractive to other private entities to not obtain a license and have the exception.
Mr. Chairman,
Senator Dougal.
I very much understand the issue that Delegate Sullivan brings, but I think in a policy issue, it is significantly broader, because if you start saying, because you're a private club and you do this, every private club that exists is going to do it. Senator McPike is going to bring his robotics private club bill next year.
I got it. Senator Cosgrove, you had a question?
Yes, Mr. Chairman, and it may have nothing to do with the bill, but I'm just not sure. Yeah, any private swim club, most of the time when you go to a swim club, they prohibit glass containers. Is this in any way going to interfere with the ability of the swim club to define what kind of container is used?
I haven't lawyered that, Senator, but my guess is the answer is no. They can set their own rules. It's a private piece of private property. They can set their own rules. They can say what you can and can't bring into the club, and they could still take the position that you can't bring alcohol into the club because it's a private. But what this does is simply say you don't have to get a banquet license, have your board go through the background checks required for a banquet license, that sort of thing.
And, Mr. Chairman, one final question. Expanding on what Senator McDougal was talking about, a lot of golf courses, where I live, have swimming pools or golf clubs, and basically, I'm just wondering if this would expand to the entire golf course. I guess I'd defer to Senator McDougal if he has an answer for that.
Mr. Chairman,
Delegate Sullivan, go
the
ahead.
bill on its face limits it to swim clubs. And so it is meant to create a very small exception on what is a frankly long list of exceptions.
Mr. Chairman.
Senator Servo.
Thank you, Mr. Chairman. So, just for some context, I guess, in Northern Virginia, before probably about 1985, when HOAs started coming into vogue, a lot of neighborhoods didn't build swimming pools along with the neighborhood, and so a lot of times what you had was groups of people would go out and they'd buy like 20, 30 acres of land and then set up a 501c whatever to build a pool and some tennis courts or whatever. I've been a member of one since 1975. We have a pool, I think 8 tennis courts, and then a very large area where people just come and cook out, and they bring a bottle of wine or whatever and hang out. I had no idea I was breaking the law for the last 40 years, but at least since I was 21. But in any event, it's not just endemic to this
being
one.
recorded, you realize.
Right. But it's not a problem that's just endemic to this one club. I mean, there's probably dozens and dozens of these, at least in Northern Virginia. I can't speak to the rest of the state, but I guess this one has a lot of lawyers that split hairs, so.
Mr. Chairman, if I could expand on that. If I gave the impression that this applies to just one club, I didn't mean to do this find by a member of one club sent shockwaves, frankly, through certainly my district and I think all around Virginia among the swim community, because it was a discovery that, as Senator Serval suggests, no one knew was out there, and people have probably been therefore breaching for a long time. So this, I don't know if you've heard from any constituents on this bill, but I certainly have.
Do you have any patron swimmers that want to speak to the bill? Anybody opposed to the bill?
Me.
All right, committee operates on motion.
report.
All right, it's been moved and, somebody second? Seconded by Senator Sproul that this bill reported. Clerk, call the roll.
Ayes 11, noes 4.
Ayes 11, noes 4. You're out of here.
Thank you, Mr. Chairman, members of the committee.
Trying to see who's in the audience. Delegate Rasul, you're up.
Thank you, Mr. Chairman, members of the committee. There is a substitute with technical amendments offered.
Committee will bring their
Social
attention to
Services
11:30.
On House Bill 1130.
All right, it's been moved and seconded to approve the substitute. All those in favor say aye. Those opposed? All right, the substitute's before us. Go ahead, Sam.
Thank you, Mr. Chair, members of the committee. Comes at the request of the Department of Social Services, which simply allows them to provide licensure to assisted livings and adult daycare centers that are operated by agencies of the Commonwealth. As you might recall, we passed a similar measure last year, which allowed for the licensure of child daycare facilities by the Commonwealth. These facilities want to be licensed, want the same oversight to ensure that our adult daycare centers and assisted living facilities have the same oversight as private facilities.
Delegate Rasul, how many of these do we have in the Commonwealth?
There are a couple, but there is a movement, and Tara from Department of Social Services says that they're studying actually bringing a couple of more on board. So there aren't a lot throughout the Commonwealth, but for example, at Virginia Tech, with the legislation we had last year, we had a child daycare facility that was not actually licensed, and it wants to be licensed, and it had to have a special memorandum of understanding through the AG's office. But now we're just trying to put them in the same posture as we did the child daycare facilities.
So would this also apply to our new Veterans Care Centers that we're putting online?
Great question, Mr. Chairman. No, sir, it would not apply to the Veterans Care facilities, which are the skilled nursing facility, a piece of that. Some of them, I think, do have an assisted living portion, and we would see how they would actually be set up.
Anybody like to speak to the bill, or members have a question for Delegate Rasul?
Mr. Chairman.
Senator McDougal.
Just skimming through this, because we just got the substitute, when, like on lines 55, and I think it's repeated in other places, other than an assisted living facility operated by agency of the Commonwealth. So we're saying if you're a Commonwealth agency, you don't have to go through a licensing process, but if you're a private, then you do?
Mr. Chairman, Senator McDougal, I'd love for Tara from Department of Social Services to explain why there was the need for this technical amendment that they brought forward through David May here.
Tara, come on up. You're his lifeline, so it's all between you and him.
It's a good one. Not a bad lifeline to have.
That's right.
Tara Ragland, Department of Social Services. Initially, the adult daycare centers that were affected, it affected their ability to receive funding through some of their nutrition programs. So that's why they wanted to be licensed and asked to be licensed. And can you repeat the last question that you had?
Well, Mr. Chairman, it's on line 55, it says, may require assisted living facility other than assisted living facilities operated by agency of the Commonwealth. So that creates an exclusion for for those operated by the Commonwealth is the way I'm reading that.
No, they will all be licensed, and that's the requirement, and that's what we're trying to do, is ensure that they all are licensed. It's just the way that what happens is the way that the civil penalties are enforced would be different for agencies of the Commonwealth, so that one state agency cannot sue another state agency, and that's kind of the bottom line. So the secretary would have the final word on any type of sanction that would come about for an agency of the Commonwealth. But they would all be required to be licensed. That's what this does. So it kind of brings everybody onto an even playing field is what we
Okay.
kind of want.
Senator McDougal, I'm gonna ask David to look at it real quick.
I'm trying to see how exception is creating an even playing field.
Can you? Yeah. Yeah, go ahead.
Mr. Chair, Mr. Dougal, just to, Senator McDougal, sorry, to put it in perspective, basically, the overall bill allows these facilities operated by the Commonwealth to be licensed. However, throughout the bill, we have exceptions here and there for them to be treated in certain ways. The reference on line 55 is one of them. If you keep reading on to line 56, it says to contract with an individual licensed by the Board of Long-Term Care Administrators, and it goes on. This is just one of the requirements that other licensees would be subject to who are not operated by an agency of the Commonwealth. If that answers your question.
Senator McDougal.
Mr. Chairman, I think that highlights my concern. Why are we treating state agencies different than private entities? If there's a reason, let's talk about it, but I'm not sure why.
And, Mr. Chairman, Senator McDougal, it's a great question. There are just some limitations that prevent us from treating them exactly the same as private entities, and Tara highlighted one of them earlier. For example, they're just not able, we can't have them suing each other, for example. So we had this come up last year with the child daycare facilities, and we had to make sure that we went as far as we could because we wanted them to be as similar to the licensure for private child daycare facilities, but we couldn't get it exactly the same.
Mr. Chairman?
Senator McDougal.
This one on line 55, and it was the first one I came to, specifically seems to be not that example of suing, but saying if you're private and you're found in a certain status, then you have to do these things. But if you're public and you're found in that same status, you do not have to do those same things. So that's where I just have some concern. So maybe I'm missing it.
So prior to this, what we're trying to do here, they were not subject to licensure at all, which means that concern is very valid, that they would not have an inspection process at all. So this makes them subject to licensure by Department of Social Services. This just lays out different ways that they have accountability toward that and what can be done. We cannot, under this, assess a civil penalty or basically go to court, but there are other things that can be done to bring them into compliance with the code, with our regulations.
Okay. I think you have a few more folks behind you.
Mr. Chairman, Carter Harrison from the Alzheimer's Association. To answer Senator McDougal's question, basically the Commonwealth can operate an assisted living facility now without a license, just like they could the child daycare centers and the adult daycare centers. This now puts some parameters in place, not as many as exist in the private sector, but does put parameters in place for them, which would not be the case under the current law right now, because under sovereign immunity, my understanding is that the Commonwealth can operate it without having to have the license, which is what Terry was trying to say.
Mr. Chairman.
Senator McDougal.
So why wouldn't we want to make the Commonwealth have the same requirements? If they found that there's an imminent or substantial risk of harm to residents, why wouldn't we want to make the Commonwealth also contract with somebody who is licensed from the Board of Long-Term Care Administrators?
So, Mr. Chairman, while this is not my bill, I actually personally happen to agree with your comment about that. But the bottom line is right now, they can do it without that piece in place. So we were trying to take a bite out of the apple at least to put some parameters in place.
Got it.
Mr. Chairman, I see what the trepidation is. Right now, the state facilities
They got nothing.
have no regulation in essence at all. We're putting regulation on the private facilities, but we're putting more regulation on the private facilities than we are on the state facilities. I'm probably going to move in just a moment to take some of that out to make them more equal.
And just one thing,
Tara.
and I wasn't here, involved in the department prior to this, but there was a movement by, I mean, there was some General Assembly enactment a couple years back to do this, to take this away. So that's kind of we were trying to fix that a little bit, and I don't have the history in the background, not to know exactly where that came from, but
All
there
right,
was
why don't we
some-
do this? If Senator McDougal is going to do some scribing on the bill, take this by temporarily, Sam, and if you want to get with Senator McDougal and work through it, or do we want to try to have it go by for the day and
Mr.
pick it
Chairman,
up?
Could I ask you a question, please?
Just let me go with Senator D. Steph, and then I'll
If we
get to
could
Senator.
take this by for the day, here's why. If you look at line 241, 242, when you do this, we're giving the secretary the authority that's not subject to judicial review. So we are truly, when the secretary makes a decision on this, we're taking any way to appeal it out of the code. So line 241, 242, then if you want to look again at 255 through 259, we're basically giving we're giving the secretary an opportunity to be judge, jury, and executioner here in a position. So if we're going to take this by to work on it, we need to take it by longer than a few minutes. I think this needs some real help.
Okay, Senator Sproul?
Yes, Senator Duga. A question.
Hey. Senator McDougal, Senator
Yeah,
Sproul has a question.
My question to you, then are you trying to make this on equal par for both ways, or just limited to what you're trying to do?
Mr. Chairman, I was just speaking with Mr. May, and in looking at it, it seems like maybe I grabbed that line 55 was the one that creates a non-equal setting. I think and I'm trying to digest it quickly because we just got substitute, the issue that Senator DeSteph just brought up probably is on the appeal side, and we probably do need to have an appeal side different for the state versus a private, because the state would go through the executive branch already. So I can see a logical reason to have that being different, but I don't know that the issue on 55, I see a logical reason for that being different. So me personally, I'd probably be okay if we take, with my motion to remove the lined language on line 55, the added language on 55, and that would make them equal enough.
Okay, thank you.
Mr. Chairman? Mr. Chairman?
To add the language. Who's hollering me now?
Mr. Chairman,
Douglas will-
I have no problem with taking this by for the day if that's the committee's pleasure, while we work to improve the language.
All right, so I have a motion to take it by for the day. Is there a second for that? All right, it's been moved and seconded to pass this by till next week. All those in favor say aye. Any opposed? All right, Tim, if you'll get with Senator McDougal and start scribing and figure out what you got to do to fix it, it'd be
Will
great.
do. Thank you, Mr. Chairman.
Yep. Delegate Hope.
Good morning.
Good morning.
I have two bills before you, House Bill 797.
All right, we'll take up 797 first.
Thank you, Mr. Chairman. This is a very simple bill. It recognizes the new ways that in prisons you can communicate with family members using electronic means. And so think about ways that we use Skype and FaceTime. They use a similar mode of communication with people remotely to communicate with families. And the goal, of course, is to make sure we can continue to connect the inmates with their families, particularly ones that are getting out. So what this bill actually does is Section 1 bill that directs the Department of Corrections to develop regulations around electronic visitation. And the electronic visitation cannot replace in-person visits. And so that's all that the bill does before you.
Okay, so this is catching us up to the way we communicate now with new electronics and everything. I'm
That's
just
right.
trying to make sure it covers everything.
Mr. Chairman,
Senator Black.
question to this. So the warden's going to be able to restrict this in any way that he wants, isn't he?
It's optional right now, and I have the Department of Corrections that is here. It's optional in prisons to have electronic visitation.
In other words,
They're not required.
my concern is just that the warden stays in control so that if, you know, for example, he may have somebody who's misbehaving and he just wants to take away that privilege. He can do that?
Absolutely. This bill wouldn't even just make that decision. It allows the department to set those regulations, and they could do that if they wanted to. Of
Okay,
course.
thank you.
It's completely permissive to them.
Any other members have a question? Any member of the audience wish to speak to the bill? All right, been
Second.
moved and seconded to report the bill. All those in favor will vote aye.
Sorry.
934.
11.
Mary Ann, what was that vote total?
I'll run that up, sorry.
You want to redo it?
Yeas 13, nays 0.
Okay, so that bill's out of here. What's your next bill?
Thank you, Mr. House Bill 934.
All right, may I bring their attention to 934?
This House Bill 934, this is an effort to try to free up inpatient psychiatric beds. If you have someone that is in jail right now that you believe does need to have treatment, involuntary treatment, and the jail wanted to, and this is permissive, the jail wanted to give those psychiatric treatment to the patient, they would be under this bill allowed to seek permission, petition the court to authorize the treatment in the facility, in the jail, for the individual that's not capable of giving consent. What this bill does is I believe that the jails already have this ability to do this if they want, but what this bill does is it lays out parameters and protections for the inmate. It spells out that if the jail wants to do this, that it requires representation by the individual before the court. It lays out that they have the opportunity to make appeals also. It requires the medication be admitted by a professional. And again, this does not require a jail to do this, but if they have the facility and the capability to do this, a separate place to do this, then they would permit it to do so. But this does lay out some protections for the inmate in that case. Otherwise, what we're doing with these individuals is we're sending them for inpatient treatment. And if we have the ability to provide the exact same treatment in the jail, we should do that because that frees up necessary bed space.
Okay. Anybody have a question on this? Senator Sherwood.
A question for the patron.
Go ahead.
No, there you are.
Would this overrule, if the person happened to have an advanced medical directive, would this overrule that? So like if, say, somebody was locked up and they'd given authority to their wife to make decisions to them if they were medically incapacitated, would this overrule that?
Well, I mean, they would go before the court. So they would petition the court and they would have representation before the court, and the court would consider that. I mean, it's no different than the, I'm sorry, we do have a substitute. David, Mr. May?
Mr. Chair, we do have 3 line amendments. The reason I brought it up is just because it addresses that concern as part of it. The first is on line 74, after facility period. Insert, upon filing the petition, the sheriff or administrator shall provide a certified copy of such petition to the prisoner for whom treatment is sought, and if the identity and whereabouts of the prisoner's next of kin are known to the next of kin. The second is on line 75, after finding, strike the comma, insert Romanet 1. And the third is on line 78, after prisoner, insert semicolon, Romanet 2, that the facility designated for treatment by the sheriff or administrator has sufficient resources to safely administer the treatment and to respond to any adverse side effects that might result from such treatment. And 3, that no person authorized to make medical decisions on the prisoner's behalf is available to authorize such treatment.
Mr. Chairman,
Mr. Chairman.
Senator Sproul and Senator Sherwood.
on line 7 and 8, you said the facilities designate the sheriff or administrator to be low. How are they able to administer treatment if they are not qualified? I'm looking at line 7 and 8, what you just read on line 7 and 8. So who is the person to administer, to take care of this patient if they can't do it? I don't see when you were saying that someone who is qualified to do so.
It would more than, I can answer the question, it's more than likely be the CSBs, but of course, the jail could contract with whomever they want to bring in a hospital, for example, but it has to be someone who's licensed and authorized to administer the treatment.
Thank you.
Okay. It's been moved and seconded to move the line amendment. All those in favor say aye.
Aye.
Any opposed to that? Okay, so that line amendment's before us. Senator Sherwood, you had a question?
Yeah, it did, and maybe this is, I'm not sure if this is for the patron or for council, but the line amendment that was just read addresses, I think, the advanced medical directive situation. But I thought I heard council read that you have to notify next of kin. Wasn't clear to me if that rules out spouse. I'm not clear why you wouldn't notify spouse in addition to next of kin. Unless, I don't know whether next of kin encompasses spouse, but.
That would be correct. It did not include the spouse. I believe it would include, but at the patron's request, we could easily add that in if you want.
Okay, then I'd move we add spouse and next of kin.
Is there a second to that motion? All right, it's been moved and seconded to add that line amendment. All those in favor say aye.
Aye.
Any opposed? Okay, so that's scribed up.
Mr. Chairman?
Senator Sproul?
The spouse not next of kin, I'm trying to figure out, I thought you being a lawyer is just a question. It's different? Okay, I know that.
Okay. Anybody in the audience wish to speak to the bill? Has the Sheriff's Association got a position on this thing? Come on. Alexander.
Mr. Chairman, Alexander McCauley, on behalf of the National Alliance on Mental Illness, the Virginia chapter, we support the bill.
Okay, thank you.
Mr. Chairman, Colleen Miller from the Disability Law Center. I really want to thank the delegate for working with us, particularly on those amendments, and we support it with those amendments. Thank you.
Okay. Anyone else?
Mr.
right.
Chairman,
Senator McDougal?
can we affirmatively hear from somebody from either the regional jails or the Sheriff's Association?
Mr. Chairman, Mike Edwards with Kemper Consulting on behalf of the Association of Regional Jails. It's permissive. We're fine with the bill as it is. Yes, sir.
It's my understanding that there could be a fiscal impact on this bill. At least that's what we've got. That's indeterminate. So if we report the bill, we need to send it to finance, which will go to Senator McDougal's subcommittee. So, all right.
Second.
All right. So we have a motion to report and re-refer to finance. Is there a second?
Second.
It's been moved and seconded to report and re-refer. Clerk, call the roll.
Thank you, Mr. Chairman.
Delegate Peace, are you here now? Come on up.
Thank you, Mr. Chairman, members of the committee. House Bill 852 comes as a recommendation of the Commission on Youth to direct the Board of Directors of the VABC to establish and appoint members of the Institution of Higher Education Substance Use Advisory Committee to address concerns over abuse of alcohol and substance use in higher ed. I believe there was a similar but not identical bill Senator Corolla had that was uncontested. What we did on the House side with the patron's consent was to conform her bill to this bill that's before you.
Okay.
And that was reported out of general laws this week. So I don't believe there's a fiscal impact to this and that ABC does support the bill.
Okay. Anybody have any questions? Because we've heard this before. Senator Favolo, you're good with conforming on the House side, right?
Yes,
Okay.
yeah,
All right.
that's a good bill. I'd second that motion.
Okay. Senator Cosgrove.
Mr. Chairman, and members of the committee, I think it's important that we all know that when we go to the other side's committees, when they say, let's conform the bill, of course we're going to say yes. Otherwise, the bill's going to get killed. So just the blanket, oh yeah, well, we conform to the House and the patron's okay, doesn't necessarily mean it's okay. And I mean no disrespect in that. It's just that we've all been in that situation.
Yes, Mr. Chairman, Senator Cosgrove, Senator Favola and I serve on the Commission on Youth together, and we were able to collaborate on what would be the best language to move forward, and that's why we are in this posture, and she supports the House version of the bill that's before you. And certainly, I think, and as a former House member, you know, Senator Cosgrove, we try to extend every courtesy we can to the senators when they come over to visit us.
I've had that courtesy before extended to me many times.
Mr.
So
Chairman.
I'm going to extend some courtesy to you as
Mr.
well.
Chairman.
If we report the bill, it's got to go to finance. There's a nice courtesy for you.
Well, thank
All
you.
right.
I don't believe it has fiscal impact, but I'm happy to go where we said it.
It's got to go. I got a letter that
Thank
says
you.
it's got to
Thank you
go.
very
So the
much.
motion is to report and refer to finance. Is there a second?
Second.
All right, been moved and seconded. Committee will vote.
Thank you all very much. Appreciate it.
Delegate Bell, you're up.
Mr. Chairman, members of the committee, I'm not aware that there's a Senate version of this.
There is not.
That's
It's a
fine.
unique bill.
So, Mr. Chairman, members of-
511.
This is a fairly modest bill. It was brought to me by a constituent. He was a grandfather. His daughter took up with a man from Pennsylvania they discovered to be a registered sex offender, and he was worried about the health of his granddaughter and found it very hard to get anybody else to pay attention. And so Virginia law already has a definition in the child abuse section about leaving a child with if there's two categories of sex offender, this is the more serious one, the violent sex offender with whom the child does not have a family relationship. This would say that when the call comes in, social services has to investigate. It would also add it to the list of calls that social services gets that they have to tell law enforcement about. That's the bill.
So there's a 2-hour time frame when, the way I read the bill. Is that correct?
Yes, sir. There's an existing set of things that when they come into social services, we say this is not something to get to next week. You got to call law enforcement right away. This would add this to that list.
So Delegate Bell, how probable is it that they can do that within 2 hours? I'm just worried about the time frame wise. I know
they
it's
do it for all.
important.
They do it for all the rest.
Okay.
There's a protocol they have where if it's in this category, you call right away. In this instance, the issue would be law enforcement has information about probation, perhaps, sex offender registry, other laws that might be being broken. And so we thought this would be, the question is whether we think it's urgent enough. Other things they get to when they get to them. The other one, they notify law enforcement right away. I believe it's in category number 2, but if it's the pleasure of the committee to take that out, then it would still have the section that said social service would have to investigate.
Okay, let's see what the pleasure of the committee is.
Mr. Chairman.
Senator Cosgrove.
I just want to bring the committee's attention to the docket today. This says that it passed the bill in the House 86-0. Actually, if you go and you look at LIS, it was 86-10 with 1, 2,
I don't think it
3,
was
4,
unanimous.
5, 6 or 7 meant to vote nay, voted yay, and vice versa.
Right.
So there was a little bit of a
Yeah, it was.
pushback on this. So it wasn't unanimous out of the House. And I'm going to support your bill. I just want to make it
That was my recollection, is that it was not unanimous off the floor.
No problem. Anybody have a question for him? Okay, so it's been moved and seconded to report. Let me find out if there's anybody in the audience who wants to speak to the bill. For or against, come on up.
And just Carl Ayers, Child Welfare Director, on behalf of the Department of Social Services, we support the bill. We already do this for numerous other options. This just expands it from that piece of it. We have a reporting process within 2 hours. We can do this, no problem.
Okay, great. So we don't need to monkey the bill. All right, so it's been moved and seconded to report the bill. All those in favor vote.
Mr. Chairman, thank you.
Yeah, you bet.
Yeas 15, nays 0.
15-0. Okay, Delegate Sickles.
Mr. Chairman.
You have 1439?
Thank you, Mr. Chairman, members of the committee. We're having a difficulty with 2 different but potential line amendments on this. When we want to make sure that the council's line amendment is the same as the line amendment that I have in my folder. This bill that we're talking about is a bill that you passed 40-0. Came out of the Rules Committee. It was Senator Mason's bill to, in a regulatory process, the 10-person small assisted living facility exemption was not included. That's what this bill does. You passed it before, and we're checking the line amendment here to make sure that the Department of Social Services has the right one, Mr. Chairman. It's a technical bill.
Okay.
It's a regulatory relief bill, which I'm known for. And so I'm just, you know.
So you're running
trying-
for reelection on regulatory reform?
Well, we gotta make the government
I got it.
work as smooth as possible.
All right,
Mr. Chairman, there were
go ahead.
3 amendments: emergency clause, 280 days, and one more.
Yep, Mr. Chairman, I don't think the department likes those amendments anymore. That's
Oh,
what I
really?
think, and I think council can tell you here
All right,
what they
David.
want to do.
School me, David.
So, Mr. Chairman, there's going to be 2 line amendments, which I will read. Essentially, what they do is they strike all of the language on 14 and 15 up through living facility on 16, taking out the second part of the exception. So the line amendments would be the first on line 11, after impairments, insert who cannot recognize danger or protect their own safety and welfare. And the second would be on line 13, after present, strike the remainder of line 13, all of lines 14 and 15, and through facility on line 16.
Move the amendment.
Second. A motion, there's a second to accept the amendments. Those in favor, please say aye.
Aye.
Opposed, no. All right, the amended bill is before us.
Okay, committee's heard the bill. Anybody have a question for them, what they're doing? Anybody in the audience wants to speak, other than peace in the valley? Everybody's good? Okay. It's been moved and seconded to report the bill as amended. All those
Thank you.
in favor, vote aye.
Thank you, Mr. Chairman.
Okay, we're going to take up Delegate Russell. I think we have white smoke on your bill. So
Mr. Chairman,
we're
I
gonna
move
take
to
it.
reconsider the motion by which we passed it by for the week.
Okay, it's been moved and seconded to reconsider, in which we passed it by for the week. All those say, vote aye.
Aye.
Any opposed? All right, so that's unanimous before us. Okay. You want to tell me what we've got, so we're there?
Thank you,
Sam?
Mr. Chairman. Mr. Chairman, we have a line amendment that I'll have staff record on line 55.
What line is that?
Line 55. If staff would report the floor amendment.
Senator McDougal, is that it, address?
Yes, Mr. Chairman, and we talked with Senator DeStef, and with taking that out, it makes the treatment between private entities and public entities, state-owned entities, the same, except for the appeals process, which Senator DeStef correctly determined. But the reason it's different appeals process is you would not want the administrator of a facility appealing past their boss, which would be the secretary. And so that's why that appeals process would be different, but private entities would still be able to appeal through a court process as well. So Senator DeStef did pick that up accurately. But I think that taking this line out creates the equal treatment that Senator Sproul is concerned about.
Senator Sproul, are you good with it now?
Yes, sir.
Okay. All right, any members have any more questions for Senator Rousseau? All right, it's been moved and seconded to report the bill as amended. Committee will vote. Unanimous, there you go.
Thank you,
You're
Mr.
outta here.
Chairman, members
You
of the
bet.
committee.
All right. If I didn't bring it up earlier, what was the bill number, David? 614? I need a motion to take House Bill 614 and re-refer it to Education and Health. Good. All right, it's been moved and seconded. All those in favor say aye. Any opposed? No, we got to vote, sorry. Delegate Tran. And for some of the members that have been waiting, there is a sign-up list in front of me where people signed up, so if some of your colleagues out-trumped you getting down here. I'm just going by the list I have in front of me. Delegate Tran, welcome.
Good morning.
You have House Bill 1061?
I do have House Bill 1061.
Okay.
It provides technical updates to sections of the code related to the Department of the Blind and Visually Impaired to make sure that the code actually reflects the programs and services that the department provides. I can walk you through why we have suggested those changes. I also have one of the deputy commissioners from the department to answer any technical questions.
So First, let me ask my members, anybody have a question? And if you do, we'll ask that, and if the commissioner would come up and speak to the bill just briefly and let us know it's in good order, we'll move forward.
Here he comes.
Good morning, Mr. Chair, members of the committee. The Department for the Blind knows this bill and supports it.
Okay. All right, it's been moved and seconded to report the bill. Clerk will call the roll.
So exciting.
This is your first bill through the Senate?
Yes.
Wow. Congratulations. Yeah.
I'm so excited. Thank you so much.
I should have highlighted that to the committee beforehand. You didn't get enough hazing to come through here.
Bye.
Congratulations.
Thank you.
Delegate Robinson.
Good morning.
House Bill 1379.
So 1379, what it will do is when retail entities now, they're required to keep their records for 2 years for, their ABC sales and food and things. But a lot of them now, because they do everything electronic, they may not be able to keep their records for, on site for more than 6 months, because if you look at big giant stores and things that are out there. So what this bill does is it just says that what ABC can do is give them with good cause 3 days to produce those records.
So, Trav, did you move to the back again? Yeah, as chairman, I want to make sure maybe we just have to put you at the table up front, keep you.
That'd be great. Thank you, Mr. Chairman.
We'll give you water.
Thank you. Mr. Chairman, Travis Hill with ABC. Yes, sir, the delegate has explained the bill properly. The one thing that we had asked for is to have some good cause, because we didn't want a licensee who, when we discovered they didn't have records, go, oh, well, they're electronic, and then we have to give them 3 days to then mock up documents. So here, we would anticipate being able to give them up to 3 days, and also making sure they demonstrate they're out there somewhere, and this just isn't a 3-day pass to go into Excel and start creating things.
Gotcha.
But we're fine with the bill.
Okay, thank you, Travis. Anybody wish to speak to the bill in the audience?
Mr. Chairman, I have a question for the patron real quick. I'm sorry, for Travis.
Senator Sherrill and then Senator Cox.
Yes, sir.
So I would think that the original reason for having the records on site is that you want to be able to just show up and look at them, so that the licensee doesn't have an opportunity to doctor the records or go out and goof around them before you look at them. And so, are you sufficiently satisfied that this 2 or 3 day wait period and having an offsite electronic is not going to encourage or create sort of forgeries? I'm not worried about the big box stores or big grocery stores or people like that, but I could think some smaller licensees could more easily evade, things by having it electronic, not in their store, and having time to figure it out, like you said.
There are already exceptions to when they can produce regular business hours, that sort of thing. Tom Lisk is in the audience and can explain, since he brought the bill forward. But we think we can ask the right questions and start to determine. Generally, these are large licensees that have off-site records, and we think we can figure out when we've got somebody who's got records somewhere versus they're just trying to figure out where they can make them up.
Okay.
But I'd turn the microphone over to Mr. Lisk.
Let me see what Senator Cosgrove, and then Senator Pavola, you have a
Yeah.
question on this bill too?
Just very briefly, changing on line 31, we strike the word "to" and insert "3." On line 31,
Going from 2
the
days
word
to 3
"to"
days.
is stricken and 3 is inserted. I guess the question is, Mr. Hill just said that basically they could give them up to 3 days. I believe the way this is written, it says it will be 3 days. I may be misreading that, but.
The way that we've interpreted it, Mr. Chairman, is they may obtain board approval up on line 30. We believe the way we would interpret that is that the board could give up to 3 days based on the explanation given by the licensee.
David, you interpret it that way as well?
Mr. Chair, I would, if it was appropriate for the committee, we could also add language just stating within not more than 3 days, and then there would be no discretion involved.
Okay. Are you fine with that?
Yeah.
Okay.
I just want, if, Mr. Chairman, if Mr. Hill wants it to be discretionary for the board, you can have 1 day, 2 days, or 3 days. I think it ought to spell that out. Right now, it says, the board may allow them to provide this within 3 days. All right, so basically, I don't think you have any wiggle room in that 3 days, the way that this is in here, so.
So
If you like
you
it,
all,
yeah, whatever.
you okay with that amendment, Mr. Lewis? Okay, all right, so that
Mr. Chairman.
amendment, Senator Sproul?
Then if that was me and I would, within that 3 days, within 3 days, and I will hire him as my lawyer, could you play with that word within or may? How would you interpret that if I'm hiring you as my lawyer?
Mr. Chairman,
Senator McDougal.
we always mince words, depending on what side we are, but I think Mr. May's solution, up to or no more than 3 days, probably fixes what Senator Cosgrove's concerns they expressed were.
Thank you.
Okay, so it's been moved and seconded that line amendment. All those in favor say aye.
Aye.
Any opposed? All right. Does anybody else have a question, or does anybody want to hear from Mr. Lisk? Everybody understand what's going on? All right.
I would second.
Been moved and seconded, report as amended. Clerk, call the roll.
I'm gonna have to start paying you out the wall.
Thank you very much.
You bet. Okay, Delegate Hurst.
Thank you, Mr. Chairman, members of the committee. Before you is House Bill 486, which simply makes 2 technical amendments to legislation that was passed last year. Last year's bill enabled for the establishment in Montgomery County an old, no longer being used elementary school to be redeveloped for mixed use, including a farm-to-table restaurant that needs a mixed beverage license. However, when it was passed last year, the description used for the property inaccurately described it as being west of an intersection with McCoy Road in Montgomery County. It actually lies east. And then as we were continuing to look at this with the county, Montgomery County's planning director actually said that the numerical feet adjustment needed to also occur from 1,128 feet to 1,600 feet, again, east of the intersection with McCoy Road. And so by passing this bill, we would be able to continue the redevelopment of that old elementary school so it can be senior living, some apartment housing, and also this farm-to-table brew pub. And with that, Mr. Chairman, I'm happy to take any questions.
Any members have a question on this bill? It's really, really simple. It adjusts the feet in the direction of the intersection. So,
Mr.
Senator
Chairman, I
Cosgrove.
move to report the bill.
All right, hold on one second. I got questions first. Senator Cosgrove.
No, Senator.
Senator Eastep, go
Mr.
ahead.
Chairman, Delegate Hurst, is this specific legislation?
Mr. Chairman, I would say that it's not because we have within already this part of Title 4.1 where we have been making different exceptions for certain parcels of land in counties in which they have not put it to the voters for a referendum to have a liquor by the drink. And so in that case, we need to go parcel by parcel to help make sure that we can continue to grow my part of the district and be able to provide some of these mixed beverage licenses for quality of life amenities.
So, Mr. Chairman, Delegate Hurst, if I may.
Senator Eastep.
So if this isn't considered specific, how would you describe specific?
Mr. Chairman, to the senator, I would say that specific legislation, as my understanding from when it's come up over in the other chamber a couple of times, really would be something that is trying to add additional code language that would only pertain to one particular, set of circumstances, but might, not be appropriate to be introduced in that fashion. I think because this was already a part of the code and we needed to make an amendment to this code in order to be able to have the economic development opportunity occur in Montgomery County, that we needed to just amend something that was already within the current code section.
Senator Cosgrove and then Senator McDougal.
Delegate Hurst, basically you're making a change in this Christmas tree bill from 1,128 feet to 1,600 feet, and then a 180-degree change from west to east. Do the prior patron of this have a directional problem?
Mr.
A
Chair.
longitudinal problem? A measurement problem?
Mr. Chairman, to the senator, the patron that introduced this last year is no longer a member of the House. I would.
Is that because he couldn't count, or what? Don't answer that question.
All right. Senator McDougal.
Mr. Chairman, that was sort of my direction. It wasn't the feet so much, but the east versus west on the parcel. And does somebody who now thinks they have the ability to do something because it's in the code, are we taking that away? So I guess my question's a little bit different. Does somebody have a right today that we're going to be taking away by this? I don't know what is 1,168 feet to the other side of the intersection.
Mr. Chairman, to the senator, on the other side for where that boundary would actually be, it's along Price's Fork and McCoy Road. So I take that whenever I go from Blacksburg to Radford to go travel in my district. If you were to look at 1,128 feet to the east of the intersection of McCoy and Price's Fork, it's a farmhouse.
Mr. Chairman?
Senator Sproul.
So let me back up. Let's take me and Senator Cosgrove. So you're saying if Senator Cosgrove have Moonshine and Great Bridge, and interstate divides us, and I want to be able to go another 300 feet to South Norfolk, then I can have Moonshine too. No, that would be after. I forget it. I'm supporting. Thank you, son. I appreciate it.
Mr. Chairman?
That's good.
Just one more quick question. Would this be anti-farmer legislation now, since we're taking a right away from a farmhouse?
Mr. Chairman,
all right.
I don't know that I articulated my concern as well. Regardless of what's there, we have given them something in the code. So now they have a right to do something. If we pass it the way it's written, we're taking that right away. And so we're, in essence, removing something that they currently have. Well, not just without their knowledge, but without compensation for removing it. And I have a little trepidation. If we were adding west and leaving the east there, I don't think we run into that problem. But by taking one away, we might find somebody figures out what they've lost and comes back.
Okay.
Mr. Chairman, just to speak to that concern, there have been no complaints made to Montgomery County, certainly no applications to want to make any zoning requests to try and have some type of establishment that would sell any type of alcohol. And to the senator's question about this potentially being an anti-farmer and anti-farming bill, again, I will remind the committee that in order to accomplish the redevelopment that we're trying to seek here by making this technical change, it would allow for a farm-to-table restaurant that currently right now is in operation in another part of Montgomery County to expand their overall operation so that they can produce more from their farm and actually provide it locally to the people of Montgomery County.
Gotcha. I guess theoretically, Senator McDougal.
I'm going to move that we reinsert the stricken language and add this west parameters in addition to, because I do think we could find ourselves having condemned a right that somebody has, and that regardless of whether they think their farmhouse is worth it, there might be two farmhouses that have farm-to-table places now.
Mr. Chairman.
Is that okay?
Okay. So we have them. Senator Black.
Does it work to say east or west?
Mr. Chairman.
Yeah, hold on. David's got it how it's got to be described up.
Mr. Chairman, with Senator McDougal's recommended language, starting on line 53, it would read, on property located on State Route 685, approximately 1,128 or 1,600 feet west or east of the intersection of State Routes 652 and 685.
Mr. Chairman, I probably would have said, leave the language in and say, and 1,600 feet to the west of the, because if you do and/or, then you could say, well, it's only 1,100 feet to the west and 1,600 feet to the east.
So you could say
And
west
so,
and east.
I would just, I would say, leave the language and 1,600 to the west as the amendment is.
Move that amendment.
Okay, it's been moved and seconded for that amendment, Senator McDougal's amendment. All those in favor say aye.
Aye.
Any opposed? David, you
Move the
got it?
report as amended.
You got it? We just stand at ease before we take it up, just for a second.
Mr. Chair, there may be a problem with using and. I think or would be better just because the property's not going to fall in both locations. So, but I understand Senator McDougal's concern. So I would suggest possibly changing the language to 1,128 feet west or 1,600 feet east of the intersection.
Well, I still say that that's not.
Mr. Chairman,
Senator McDougal.
I understand.
He's trying to add more partial
I understand
through
what-
and or is or.
Or means one or the other. We've given the east, the west right now, they have that right today, unless we change it. So I think we can add west. My concern is taking away one or the other. So if it's or, then there's a choice, and I think you're taking away, and don't alleviate my concern.
Mr. Chairman, I believe under the rules of construction of our code, everywhere that we say or also includes and. So in this
No.
instance, you would have an option to meet one or the other or both.
I don't think so.
All right, so Chair's going to rule that the motion that Senator McDougal has is the amendment we're going forward with, David, and if it's wrong, we'll fix it next year. So that, I want it and.
Mr. Chairman.
Senator Cosgrove.
Mr. Chairman.
Senator Cosgrove.
This really is confusing. We're messing with you a little bit, but not now, okay? I really think this needs to either go by temporarily or for the day, so we can figure this out. There is a serious issue here. If you're smart, you're gonna go buy that thing, that piece of property that's erroneous.
Okay.
All right, so,
All right.
I'm sorry, I thought I was talking here, but anyway, if the committee can fix it right now, it's fine. If not, then we need to take it by.
Senator Cosgrove, I think we have it. David, do you have it?
Okay, Mr. Chair, so after speaking with Senator McDougal, the solution we've come up with is to add a completely new subdivision. So the subdivision currently in the code would remain intact. That reads on property located on State Route 685, approximately 1,128 feet west of the intersection of 652 and 685. Then we would add another subdivision after that for property located on State Route 685, approximately 1,600 feet east of the intersection of State Route 652 and 685.
Okay, let's undo the other amendment first. Having voted on the prevailing side in which we passed the prior amendment, ask that we reconsider that vote. All those in favor say aye.
Aye.
Any opposed? Okay. Strike that First Amendment that was presented, say aye.
Aye.
Any opposed? Okay, so now we have the Second Amendment. All right, it's been moved and
Second.
seconded to pass the Second Amendment. All those in favor say aye.
Aye.
All right, that's properly before us.
Move to report as amended.
Okay, it's been moved and seconded to report as amended. Committee will vote.
Yeas 15, nays 0.
15-0, you're out of here.
Mr.
sir.
Chairman, we should note with that great directional work, the delegate has doubled the economic development opportunities in this county.
Mr. Chairman?
Senator Sproul.
Mr. Chairman, I asked you earlier, I questioned the fact that Delegate James presented a long time, and I called him and asked him, did he sign up? And I see people coming in, I'm not questioning sign up, but he presented a long time, and I asked him, had he setting up? Had he signed up the sheet? He presented a mighty long time, and people coming in and going, and he's still sitting there. And I don't know what kind of, I hope he have a sign-up sheet, but it's not right for him sitting there for a long time like that he has not been called yet.
Senator Sproul, look right here, sir. Senator Sproul. So I have Delegate Foy.
Mr. Chairman, before we go, can I make a comment?
Sure.
Since these are recorded, I would like the record to show that Senator Surville, on video, voted for the, quote, Second Amendment on that last bill. Just needed to make the point.
At your service.
Delegate Foy.
Oh, good morning. I'm here for House Bill 418. My bill is a technical bill for clarification. The purpose of this bill is to clarify that the Circuit Court is to accept petitions filed by the foster parents to adopt a child that has resided with the foster parent continuously for 6 months when the child placing agency is in agreement with the adoption, and for 18 months when the child placing agency does not consent to the adoption and the birth parent's rights have been terminated. I bought this bill because there was some confusion because it seems to have contradictory language with another code section, 63.2-1210, subsection 3. So the proposed amendment is not a substantive change, but it only adds clear language to clarify the intent and purpose of this code section and set it apart from other code sections.
That's pretty simple. Any members have a question for the patron?
Mr. Chairman,
Senator Wexton?
can you explain why there's an emergency clause on this bill? Or is there still an emergency?
I don't see an emergency clause on it.
Okay.
Oh, it does, all the way at the bottom.
It may be because they want this to go into effect. Department of Social Services asked me to carry this bill because
He's right behind you, you have a lifeline.
Yes, so
Let's let him
judges
come up
are
and answer that
actually
question.
making some determinations now, but I'll let Carl speak on it.
Yes. Good morning, Mr. Chairman, Senator Wexton. The reason is that we have adoptions that are already being held up because of the interpretation of this section. So as soon as it goes in the line, we need to move those adoptions along. So that's the purpose of the emergency
Gotcha.
clause.
Senator Wexton, that suffice? Anyone wish to speak against the bill, against children or anything? Okay. All right, it's been moved and seconded that the bill report. Committee vote. 15-0. You're out of here. Congratulations.
Thank you.
Delegate James, you are up.
Yes, sir. Thank you, Mr. Chairman and committee. I have a simple bill. This bill basically just amends the definition to include youth coming out of the Department of Juvenile Justice custody for placement in independent living arrangements and facilities licensed by the Department of Social Services, and it basically codifies what they're already doing. I do have someone from the agency to testify if you would like to hear from them, sir.
Sure, I'd love to. Come on up. There is a financial impact, so this bill will have to go to finance if it's reported.
Mr. Chairman, good morning, Mr. Chairman, good morning, members of the committee. My name is James Toohey from the Department of Juvenile Justice. I'm not, I guess, just first to discuss the fiscal impact.
I'm just telling you what I get as a chairman, so it's going to finance.
Okay.
So you can hash that out with the chairman of finance if they're here, but that's where it's going.
Okay, well, thank you, Mr. Chairman, and members of the committee. What this bill is doing is it's essentially updating the code to recognize an existing practice that is already occurring with regard to independent living arrangements. Independent living arrangements exist as private entities that are normally licensed by the Department of Social Services that are for the purpose of assisting former foster care children to transition back into society or back into society and to develop the skills that they need to live independently when they do not have a family to go to when they become of age. There are a lot of services that are provided to them. They learn about financial skills. They learn about cooking. A lot of these private facilities that are licensed by DSS are apartment-like settings, and these children learn valuable skills that help them to be successful when they become fully independent. For the same reasons that these independent living arrangements benefit former foster care youth, they also currently benefit under existing practice residents of the Department of Juvenile Justice that are formally committed to the Department of Juvenile Justice. For example, if someone has been determined to be eligible for release from the Department of Juvenile Justice, and they are deemed to be someone who can benefit from a program like this, and they don't have a family to go back to. Their family could be in prison, or their family members could be part of the problem that caused them to be in DJJ to begin with. They can benefit by going into one of these ILO programs.
Senator Cosgrove.
Mr. Chairman, thank you for being here, sir, but I think this bill's in pretty good shape. So I'm going to make a motion.
I will not say another word. Thank you.
I'm going to make a motion to report and refer to finance.
Second.
So it's been moved and
Mr.
seconded.
Chairman, Mr. Chairman.
Senator
Thanks
Sproul.
for that.
Get line amendments.
Oh,
There is a line amendment,
withdraw my
David.
motion.
Yes.
All right.
All right.
Mr. Chair, there are 5 line amendments. All of them are actually the same. Everywhere it's speaking to an individual being in the custody of DJJ, it changes it to stating they are committed to DJJ. And those instances are on line 131 after was, at the beginning of 141, on line 369 after formerly, on line 374 after was, and on line 384 after was.
Move the amendments, Mr. Chairman.
All right, it's moved and seconded that the amendments after was is taken care of. All those in favor say aye.
Aye.
Any opposed?
Now, Mr. Chairman,
Mr. Chairman.
make a motion to report the amended bill and refer it to finance.
Second.
Seconded, Senator Sproul.
Mr. Chairman, this is the third time I've heard someone come before us with the bill and it's sent up to finance. And you were saying that the chairman sent up to finance. And I'm trying to read here. I don't see no reason why. And this late there in the game, being in the House as well over here now, this late there in the game, when you send something to finance or appropriation, that means it's gonna die. So I'm saying, so when you say the chairman say finance, I'm trying to read why.
Senator Sproul.
Yes, sir.
In FY 2017, DJJ placed 21 youth in independent living arrangements at an average daily cost of $225. I think those numbers have changed. I have a letter here from the chairman of finance that they want to look at the bill. I don't think it has anything to do with the status of the bill, only in a financial term that it's good to go. So we have a motion on the bill
Mr.
to
Chairman.
report and refer to finance. The committee will vote and we'll talk about it. Committee will vote.
Mr. Chairman,
Thank you.
Senator Favola.
I will just say, I think part of the fostering futures dollars that we had gotten to the budget a few years ago, which has federal money associated with it, will be a potential funding source. So.
I thank the committee.
Just FYI.
Thank you. I thank the committee.
I just have a quick question for Senator Favola. You had that bill where we extended backwards to our foster care kids, so this kind of comes in line with that same process, right?
Correct.
Got it, got it. Delegate Adams.
Good morning, Mr. Chairman, members of the committee.
Morning.
Here for House Bill 1026. House Bill 1026 is clarifying language with regard to the power of folks who have been designated by Adult Protective Services and wish to appeal that decision. This is stating what we believe to be existing law, that those decisions from local Department of Social Services are not appealable under the APA because your local Department of Social Services is a branch of county government. It's not a state agency. This comes on the recommendation of the Department of Rehabilitative Services and Aging, and was drafted in conjunction with the counsel at the Attorney General's office. I became acquainted with this situation myself in my capacity as counsel for the Pittsylvania County Department of Social Services. What happened was a local director, I think, sent a form letter that was typically used in child protective services cases, inviting an appeal, so to speak. But that was the wrong letter to send. But we also learned that there were other similar attempts at appeal initiated in the circuit court from a local agency around the same time. That case did not go any further. The circuit court judge dismissed that one. I think that was out of Bedford. But the one in Pennsylvania, the judge actually accepted the appeal, and so that's resulted in, that decision was reversed in an unpublished opinion with the Court of Appeals. And so there's no active litigation as far as I'm concerned, but this language would just clarify what we believe the law to be. I have a member from the Department of Aging and Rehabilitative Services who's here to speak to it further if the committee
Great.
wishes.
Let's have them come up. Senator Cosgrove?
Are there any amendments to this bill?
None,
amendments?
no,
Minor
no,
amendments?
none that I'm aware of.
And Mr.
Okay.
Chairman, I'd move to report the bill,
Okay, we don't want to hear from,
if he's for it.
okay, all right, that's fine. It's been moved and seconded to report the bill. All those members vote aye. 15-0, you're out of here, Delegate Adams.
Thank you, Senators.
We have one more housekeeping bill that we need to take care of, and I think that is House Bill 1017, Delegate Toscano. I know he's not here, but there's a similar bill, 682, that reported out of rehab, 14-0, and that I would make the motion to conform Delegate Toscano's bill to 682.
Second.
It's been moved and seconded to conform 1017 to 682 and get it out of here. Anybody wish to speak to that? Okay, the motion is to report. Clerk will call the roll. Probably. I think that's it. Okay, that's conformed and out of here. Is that it? Hey, let me just thank the committee for all their hard work. We just cleared the docket for rehab unless something else comes to us. We have one more bill next week, maybe 3 or 4 next week. So really want to appreciate everybody's help with that, the committee, Russ.